Hello and welcome back to the Hearsay Podcast on CJSW 90.9 FM. Today I'm your host, Spencer, a law student at the University of Calgary, joined by my co-host, Kelvin, who is also a law student at the University of Calgary. Before we begin, just a quick note for the listeners today that this discussion is general legal education and information purposes only. It is not legal or tax advice. If you're dealing with an issue, you should consult a qualified professional about your own situation. Today we're talking about a topic that affects a lot more Canadians than people might realize. Tax audits and the Canadian Revenue Agency's growing compliance powers. In the past few years, the CRA has been given significantly expanded authority to request documents, question individuals, and compel cooperation during audits. To help unpack what all of this means in practice, we're joined today by Laura Warrington, a tax lawyer from BLG. Laura works with clients dealing with CRA audits, compliance requests, and litigation, helping them navigate what can be a very intimidating process. Laura, thank you so much for joining us today. To start us off, could you introduce us a bit about your background?
Yeah, absolutely. Thanks, Spencer. I am Laura Warrington, and I'm a senior associate at Borden Ladner Gervais LLP here in Calgary. My practice is focused on anything to do with a tax dispute or controversy. So to boil it down, basically when the CRA is mad at someone, I go to bat for that person and step in and try to clean up whatever the issue might be. I have appeared at many levels of court, including the tax court, Federal Court of Appeal, and the Supreme Court of Canada, all defending taxpayers across a wide array of issues. I also deal with all types of taxes, so income tax, but also GST, carbon tax, property tax, pretty much all the taxes. And whenever there's a problem, I'm hopefully there to solve it.
Thank you very much for that, Laura. Before we dive into the specifics, I want to set the stage with some background information. The CRA has always had fairly broad audit powers under the Income Tax Act, allowing it to request records and information from taxpayers during an audit. But in recent years, courts have been asked to clarify just how far those powers go. One of the most significant cases in that discussion was Chemical Corporation and the Queen, which raised questions about the CRA's audit powers. At the same time, Budget 2024 introduced several new compliance tools, including penalties for failing to cooperate with audit requests. Additionally, Budget 2025 reaffirmed that these compliance tools are going forward and will likely come into force in 2026. So today, we're going to talk about what those changes mean in practical terms, especially for small and mid-sized businesses that may suddenly find themselves dealing with a CRA audit.
One of the major changes proposed in Budget 2024 is the introduction of something called the Notice of Noncompliance, which can trigger a $50 per day penalty, up to $25,000, if a taxpayer is seen as failing to comply with an audit request. So from a practical standpoint, I'd like to ask you, Laura, what kind of behaviors actually triggers a notice of noncompliance?
Yeah, I think the Notice of Noncompliance is a new tool in the toolbox of the CRA, and it's really at the discretion of the auditor how that's going to roll out and be used in practice. Obviously, this is not currently in force, but it's proposed, and we're expecting it to come into force in 2026. But I think generally the Notice of Noncompliance is meant to deal with taxpayers who are really not complying at all with requests of the CRA. So, for example, if the CRA is auditing you and they've asked you for your financial statements from a particular year and you are completely unresponsive to them, that may trigger the requirement under a notice of noncompliance. The one caveat I would say is the draft legislation that we have right now, it has very broad language in it. It specifically says that the minister may at any time send a person a notice of noncompliance if they determine that person has not complied in full or in part. So we're really left wondering, what does not complying in full or part mean? And I think the answer is it's up to that auditor on any given day.
Thank you so much, Laura. And another question that I have, given that our podcast is directed towards a bunch of small businesses and mid-sized businesses, if a small or mid-sized business is acting in good faith, but struggling to locate certain records, how do they distinguish between genuinely being unable to comply and being viewed by the CRA as uncooperative?
I think when you're being audited, the first step is to be constantly communicating with that auditor and establish a relationship with that person. So you want to have open dialogue, if it's over the phone or by mail, with the CRA at all times to show that you are trying to cooperate. And if you really just don't have the information that they are asking for, or you think it is very unreasonable, there may be a reason to push back against it. I don't think that is a full defense against the notice of noncompliance, but making sure you have an open dialogue with that person at all times is going to be key.
That's really good to know. And another question I had as well on the same topic is, if a taxpayer were in a situation where documents were missing, destroyed, or genuinely unavailable, is there any way for the taxpayer to pause or challenge that daily penalty so it doesn't keep accumulating?
So there is a mechanism in the draft legislation to challenge a notice of noncompliance, and it is, again, a discretionary process within the CRA. You have to submit a written challenge to the notice, and it will be reviewed. The one sort of good note for taxpayers in this situation is if your challenge is submitted and not reviewed within 180 days, the notice of noncompliance gets automatically canceled. So if you think a notice of noncompliance is completely unfounded, it would be best to submit that challenge right away and start that 180-day clock.
Another proposal that's getting a lot of attention is the possibility of a 10% penalty on the tax owing if the CRA has to go to court to obtain a compliance order. That would obviously be a very significant consequence, especially for small businesses. If a taxpayer has a legitimate disagreement with the CRA about a particular request, for example, a document that may not exist or may not actually be required, how can they push back or challenge that request without risking this kind of penalty?
Yeah, so unlike the notice of noncompliance penalties, which are just $50 a day, the compliance order penalty is very severe. It's a flat 10% of the aggregate tax payable in respect of the year that's at issue. So 10% of all tax payable could hypothetically bankrupt a company. It puts taxpayers in a difficult position where if the CRA has demanded documents and is threatening to go after a compliance order, taxpayers may buckle under that pressure knowing that this 10% penalty exists in the background. So, yes, the avenue is there to try to push back against the compliance order. There would be a hearing in federal court in front of a judge to review if the compliance order is, valid in this case, and you would be forced to produce those documents. But I think for most taxpayers, even just the looming threat of that penalty would probably push them to hand over the documents as opposed to going through that court process.
Grounded to the possible severities of this consequence, is this something that taxpayers should be trying to resolve informally with auditors, or is it increasingly important to get legal advice early in the audit process?
I think getting legal advice is always a good idea. Obviously, I'm slightly biased being a tax lawyer, but knowing the rules of the game and the landscape that you find yourself in when there are these really big penalties on the line, I think that's really important. Also knowing what kinds of CRA requests you should be pushing back against and which ones you should be complying with. As we see these rules change in 2026, I think it's difficult for anyone to navigate. So having legal advice is great, but in the event that you find yourself without legal advice and trying to sort out how to move forward, it's wonderful to always, again, keep that line of communication open with the auditor and the CRA and try to resolve any disputes over documents with them. I think that will be more and more difficult as the CRA tools up their toolbox and has all of these notices of noncompliance and penalties at their disposal.
Perfect. Thank you so much for your insightful response, Laura. And another interesting issue that we have relates to interviews during audits. So historically, the CRA has often refused to allow taxpayers to record interviews with auditors. But if the CRA is now able to compel testimony or detailed questioning during an audit, there's a concern about misunderstandings or inaccurate notes. So what protections do taxpayers actually have in that situation?
Yeah, I think maybe more generally, the recording of interviews and the way that these interviews are going to unfold going forward, being under oath, it raises a lot of questions and problems for taxpayers. In a bigger picture, I think there might actually be charter issues at play here, and taxpayers should be certainly seeking legal advice before entering into an interview with CRA if it's going to be under oath.
I guess I just have a quick follow-up based on your response. So I guess I wanted to ask, do taxpayers then have any kind of practical rights in regards to the transcripts or the recording of an interview? And if they don't, then what might be the safest way for them to protect themselves when they're participating in these types of interviews?
So I think I read somewhere that the IRS has a similar system in the US where interviews can be recorded, and there's an IRS transcriptionist that sits in the room and creates a written record of what is said. I'm not sure how that works in practice and if the taxpayers are entitled to a copy of that. The CRA has not come out and said that there will be a transcriptionist in the room or that they will be recorded in some way. I think the real problem there is that if the interviews are not recorded or a transcript is not made available, it creates a he said, she said scenario where if this dispute were to proceed to tax court, there's actually no way to prove what was said in that interview, and the CRA would have their version of events and the taxpayer would have theirs. And with the interviews being under oath in this new proposed legislation, that puts the taxpayer at risk of perjury, which is an offense punishable by jail time. So things can escalate really quickly again for taxpayers, and seeking legal advice and knowing how to conduct yourself in these interviews is going to be really important.
Thank you for that. That definitely has the potential to lead to some very difficult situations. Another recent change also expanded the CRA's ability to request information from any persons related to a taxpayer's affairs. In practical terms, does this mean that the CRA can speak with employees, business partners, clients, or even family members without notifying the taxpayer first?
So yes, the CRA now has the ability to ask any person any question or request any document that might help them perform their audit. And this is currently the law today. This isn't a proposed change. This is in effect right now. So taxpayers should be aware that when there is an ongoing audit, the CRA has the ability to not only request information, like documents, say, from your accountant or from your bank, but they can actually interview those people and speak to them and ask them questions. This is important for small businesses to inform employees across the business that this is a potential. The CRA could be interviewing you or speaking with you, and everybody should be alive to this going forward.
That is definitely something to be concerned with. Are there any limits or potential safeguards around how that power can be used?
Yeah, the only thing that really limits the CRA in any way is in the legislation, which is in 231.1 of the Income Tax Act. That preamble says that all questions or use of these powers should be reasonable. And what does that really mean? That's a big question. Knowing what is out of scope or a bridge too far for a question or request from the CRA is difficult. And again, legal advice here would be important, but maybe just a general rule or something that I like to think about is limiting the time of information that the CRA is entitled to. So let's say you're being audited for the year 2023. The CRA, I think it would be unreasonable for them to ask you a question about 1999. So, looking at the scope of what is or is not reasonable should come back to what are you being audited for, what is the year, and looking at the context of the audit. So you can think about limiting the things that you provide, answers or documents, in that way.
Yeah, that's all really helpful advice. Thank you so much for that, Laura. And another thing that I wanted to ask is, given these expanded audit powers and compliance rules that we've discussed today, what are the top 2 or 3 things that businesses right now should start changing in how they document transitions, store records, or communicate internally so that they're actually prepared if the CRA comes knocking?
Yeah, I think something that we didn't talk about, but maybe I could just raise now, the proposed changes that are coming in 2026 expand the ability of the CRA to get information and documents from taxpayers. But it also includes a change that is taxpayer favorable, which is there's a limit for things that are privileged. And that includes things that are solicitor-client privileged or litigation privilege. There's many types of privilege. So my first key takeaway would be making sure your documentation internally is labeled when things are privileged and ensuring that those things are not shared with the CRA, and keeping a paper trail of what is and is not privileged would be pretty important.
Perfect. And related to that question, I wanted to ask, what types of mistakes do you most often see from clients or from anybody in general that would often turn what a routine what should be a routine audit into a much bigger problem?
I think it's easy in an audit situation to become really defensive out of the gate, and that is a mistake. I think, first and foremost, the tax system in Canada is a self-assessing system. So we all, as individuals, file our own taxes based on our own information available at the time. And the CRA has the ability to, at a later date, not necessarily challenge us on the way that we file our taxes, but ask, hey, why did you file your taxes that way? Can you prove it to me? Show me some supporting documents. And coming out of the gate with a defensive mindset that the CRA is the enemy isn't the way to set the tone. So I think approaching an audit with a mindset of, hey, I'm here to support my tax return and show that my numbers are correct and work with the CRA to validate my return, that could possibly lead to a smoother audit and a better outcome.
Based on the recent Shopify case, the CRA is increasingly using unnamed person requirements to get data from large platforms. If a business uses platforms like payment processors, e-commerce sites, or accounting software, how much of that transactional data is realistically private from the CRA?
Yeah, great question. I think this is a tricky one, but we have to go back to what the CRA audit powers are designed for. And their information gathering powers need to be in respect of the taxpayer that they're auditing. So when the CRA is seeking information about your customers or unrelated people or entities in the course of their audit, it could be not only inappropriate, but not a power that they're enabled to perform under the Income Tax Act. So asking for lists of customers may be appropriate in some cases, like a GST audit, but it may be inappropriate in other cases where the CRA is actually seeking that information to go and audit those external people. If they're not seeking the information as part of the audit of that taxpayer and trying to do something nefarious or outside of the scope of that audit with the data, then it would be something I would push back on.
That definitely makes sense. And just a follow-up to this is, what should business owners understand about the difference between their personal data and their business data in this context?
Yeah, again, I think it comes back to knowing who is being audited and what the scope of that audit entails. So if the CRA is auditing your business and they're asking about your personal income tax filings or your spouse's filings, it may be irrelevant and outside the scope of their audit and an unreasonable question that falls outside of their powers under 231.1. I guess the personal and business lines can get blurred sometimes if you're looking at a small business, and there may be overlap there. But again, just coming back to who is being audited and what is the time frame, and is that a reasonable question that the CRA is asking?
Thank you so much for that response, Laura. And so I'd like to ask another question that would likely hit at the heart of the taxpayer directly. So what are specific red flags during a routine audit where a business owner should stop responding on their own and should instead call a tax lawyer immediately?
I think one of the critical stages of an audit is this thing called a proposal letter. So right near the end of an audit, when the CRA has reviewed all the data and documents, they've sort of put together their preliminary position, they write a proposal letter. And that proposal letter triggers a 30-day deadline to reply. And if you don't reply within 30 days with documents or evidence that counter their position, you will likely be assessed tax on that basis as is set out in that letter. So reaching out and getting legal advice at that particular stage when you have the proposal letter in hand could be really helpful. It's sort of a critical juncture, and I would say a red flag moment of an audit where you have this 30-day window of opportunity to reverse the script on what is going to happen, but it's a short time frame, and you have to make a convincing argument to the CRA to basically overturn their assumptions.
Perfect. That's really great advice. And Laura, this has been incredibly helpful. We know that CRA audits can definitely be very stressful, even for businesses who are trying to do everything right. So understanding how these new compliance rules work in practice is really important. And so thank you so much for joining us today and sharing your insights. And thank you to everyone for listening to today's episode of the Hearsay Podcast. This has been your hosts, Kelvin and Spencer. If you enjoyed today's episode, stay tuned to more episodes of the Hearsay Podcast for more conversations on legal and policy issues affecting Canadians.